All right, good morning, everybody. Let's get started. This week we're going to tackle criminal law. I've got a lot to cover this morning, so I'm going to try to move swiftly through that. But as always, raise your hand if you have a question about anything we say. We're going to have, in addition to your lecture outline, there is a case for this week, and then there are a couple of Georgia criminal statutes that I want you to look at. Please have all that read by Thursday. Thursday, we're going to discuss those things. We may have a little bit left over from today, but we're going to discuss that case. We're going to discuss the Georgia criminal statutes, and we're going to discuss some fact patterns somewhat similar to the way we did in torts. But that'll comprise your assignment. Will be questions based on what I'm lecturing on today, the case, and those Georgia statutes. So we're moving to a new area of law today, and what I want you to think about as we begin is kind of the contrast between the other areas of law and what we're going to talk about today. So far in this class, we've been over tort law. We spent 2 weeks on tort law. And if you remember, the goal of tort law was to compensate victims or compensate persons or entities who've been injured by the wrongful conduct of another. Now, in tort law, the wrongful conduct does not constitute a crime. It just constituted a tort, which enabled that private citizen or that private entity or company to sue the other person in court to recover damages to compensate them for whatever injury or damage they've had to property or person or so on and so forth. That was tort law. Criminal law is different in many ways, but in the purpose of criminal law, we have society passes laws that define what conduct is acceptable and is not acceptable. And so we have criminal law for lots of purposes. One is to punish. There are certain actions that our society deems worthy of punishment by fines or loss of liberty, in some cases even loss of life. But punishment is a main goal of criminal law. Deterrence is another main goal of criminal law. So we have criminal statutes and laws so that we hopefully will deter folks from breaking those laws, right? The punishments really are what are intended to deter people from breaking those laws, but that is another purpose of criminal law. We also have criminal law to rehabilitate. This is a purpose to a much lesser extent than punishment or deterrence, but to rehabilitate folks who are found guilty of committing crimes. So you wrap all that into one, and what you have through criminal law is that you hopefully have an orderly society where citizens know what conduct is acceptable and what's not acceptable. And hopefully, by and large, the vast majority of citizens will not engage in any of the conduct that is found to be criminal, and therefore the result would be an orderly society that is, if not free of crime, at least minimizes crime. That's the goal and the theory behind it all. Another difference between criminal law and civil law is that in criminal law, if you remember, the plaintiff is the government. So if it's a crime, if a person violates a criminal statute of the United States government, then the prosecutor will be the United States of America. If I break a federal criminal law, then it'll be USA versus Tebow. If I break a state criminal law, then that case would be state of Georgia versus Tebow. So the plaintiff in criminal cases is always going to be a government entity. One goal of tort law that is not a goal of criminal law is compensation for victims or making the victims whole. And so criminal law is not necessarily concerned with paying compensatory damages to the victim. That's not part of a criminal case. That's why we have tort law, is so that private individuals can bring those cases themselves. Criminal law is interested in punishing the wrongdoer in a way that promotes the safety of society, that punishes wrongdoers, and that deters others from committing the crime. So two totally different purposes between those areas of law. Now, that is not to say that sometimes somebody who's convicted of a crime or pleads guilty to a crime will have to pay restitution to a victim for what they've stolen. That can sometimes be a consequence of criminal law, but it is not the goal of criminal law. So in other words, the government entity is not going to prosecute somebody with the goal of making the victim whole. They're prosecuting that person with the goal of bringing justice for that person, or justice to society. Justice being a term I use loosely because it's not a term that we always can agree on what it means or what justice would be in a certain situation. And we see those situations in the news all the time. So that's kind of the backdrop for criminal law. Remember, too, that the same act committed by the same person can be a crime and a tort at the same time. So just remember that. It doesn't have to be one or the other. This morning, I could be speeding down University Avenue and be looking at my phone and rear end the car in front of me. I might get prosecuted for reckless driving, for violation of some criminal statutes about how we have to conduct ourselves when we operate a motor vehicle. But I also might be sued by the victim of my accident in tort law to recover damages for the injury or whatever I've done to the car, if the person sustained medical injuries, if the person has bills and things like that, pain and suffering, all those kind of things that go with it. So the same act could be a crime or a tort. So we want you to put tort law aside for this week, and everything that we think about in this context is going to be in the context of criminal law. Another difference between criminal law and tort law, or the larger civil law that tort is a part of, if you remember, we hammered this home, I think, in the second week, is the burden of proof. So the burden of proof, if you remember, in a civil case or in a tort law case, will be by a preponderance of the evidence. And in a criminal case, it's beyond a reasonable doubt. And that means that in this country, you can't be convicted of a crime unless the jury finds that you're guilty beyond a reasonable doubt. If there are reasonable explanations for how the crime happened other than you being the one who did it, the jury would find you not guilty. If there is some doubt, some reasonable doubt in the mind of a juror, then they are supposed to vote to find you not guilty. Now, a couple points about that. Being found not guilty is not the same thing as saying somebody's innocent. It just means that you weren't found guilty. We may never know whether somebody's innocent or guilty if they were found guilty. It just means that the jury, based on the facts in front of them, based on the arguments that the lawyers made, based on the testimony they heard, they could not say that person was guilty beyond a reasonable doubt. It also should trigger for you this little trick, in that a second ago I was talking about how the same act could be a tort and a crime. Well, it is possible, because of the different burdens of proof, that the same act could be found to be liable in tort. The actor could be found to be liable in tort law for what they did, but be not guilty in criminal law for the same act. That's because the burdens of proof are different. So the most famous example of this that I can give you is O.J. Simpson. He went to trial for murder, and he was found not guilty for murdering his girlfriend and Mr. Goldman. But in the tort case of wrongful death that those families, the survivors of that family brought against O.J., he was found liable for wrongful death under the lower standard of preponderance of the evidence. So same act, was a tort and a crime. He was found liable in tort for it and not guilty for it under criminal law. We classify crimes depending on their severity. So you've heard of felonies and misdemeanors. Hopefully all of your experience with criminal law is from stuff you've watched on TV or in the movies, right? And hopefully this week will be the only brush you'll ever have with criminal law. But you've heard of felonies. Those are more serious crimes. Each state gets to decide which crimes are felonies and which crimes are misdemeanors. Just depends on the way that state feels like that crime ought to be punished. But in general, felonies are crimes that are punishable by death or by imprisonment of a year or more. Those are felonies. Misdemeanors are usually punishable by a fine or imprisonment of less than a year. So they are the lesser category of offenses. So criminal liability, in order for someone to be prosecuted for a crime, in order for somebody to be convicted for a crime, we're looking for two things. One is a wrongful act, and you'll see in your outline, the Latin term for that is actus reus, A-C-T-U-S-R-E-U-S. It's in your notes. So I'm not going to test you on the meaning of the Latin term. It's not a Latin class. But basically the first part is, what's the wrongful act that we're looking at? The second thing is the state of mind of the actor. And that's the mens rea, M-E-N-S-R-E-A, mens rea. So we want to know what the act is, but criminal law is very, very interested in the intent of the person who committed the act. Because in general, accidents aren't crimes. Negligence isn't usually a crime. Those are what? Negligence is a, say it louder. Tort, thank you. I thought I was going to have to just quit this morning. Y'all are going to make me quit if you can't remember that. Negligence, accidents, those are things that we cover in tort law. So the criminal act is much more interested in the intent of a party. And that should make sense to you. We don't want to put people in jail for accidents or for negligence. I mean, just in general. If we're going to take away somebody's liberty, then it needs to be for something that they've done on purpose. or else something that they've not done on purpose, which we'll see in a minute. So the guilty act, the actus reus, that can also be an omission. So it doesn't have to be a physical outward act or an aggressive act. It could be an omission. Not filing a tax return, for example. It's a crime to not file a tax return or pay your taxes. I didn't take any actions, certainly, when I failed to file my tax return last year. But that is an omission that is the guilty act. So if you want to think about it in terms of being an act, think about it as the action was that I chose not to act to do something. The mens rea, though, the state of mind, we have different categories of the state of mind that different crimes require. And most of the time, we'll see in the statute itself what the mens rea is required. So I'm going to show you how that works in a minute. But let me back up for a second. Another difference that I wanted to mention up front from tort law to criminal law, or from civil law to criminal law, is in civil law, judges and courts, appeals courts, we've seen how they change the law from time to time, right? We saw that in Brown versus Board of Education. We see that sometimes in tort law. A court could create a new tort, or they could create a new category of tort, or they could create a new way that the tort is interpreted, things like that. In criminal law, the only body that can make criminal law is legislatures. So if you violate a criminal law, you have violated a statute, because remember, legislatures make statutes. Courts can't go and invent new crimes. Courts can't go in and say, this statute, I'm going to change this statute in this important way. I'm going to go in and say that the level of intent for this particular crime is going to be different. Courts can interpret the statutes, but they can't change them and invent new criminal law. Only legislatures can do that. So back to the different states of mind that are required for different crimes. And again, you'd find this within each statute. One is just intent itself. You have to actually have intended the act to happen for you to be charged with that crime. Murder is one. Murder requires intent to take a life. Now there is a category of crimes for taking a life but not intentionally, maybe recklessly, and we'll talk about that in a minute. But there are many crimes that require that you had to actually intend to do the act you did to be found guilty of that crime. That's the highest level of mens rea within the criminal statutes. Another one is recklessness. So recklessness occurs when the actor has a conscious disregard for a substantial and justifiable risk. If I open fire into a crowd, I might not have intended to kill the specific people that I killed. But my mens rea, my intent in this situation was recklessness. I opened fire into a crowd with a conscious disregard for the consequences and the risk. The risk that I undertook was unjustifiable. That's recklessness. Recklessness can result in criminal liability. There's also criminal negligence. And that happens when, if you recall from tort law, negligence is when there's a duty of care and the actor's behavior or actions deviate from that duty of care. There are times when negligence can also be criminal. It doesn't happen often because we, as a society, don't want to, criminalize things that are essentially an accident. But criminal negligence can sometimes have that result if the disregard of the duty that the person had resulted in the kind of harm that that could have been avoided if they'd just been careful. There are just some things that we deem important enough that if you're negligent in an area, you may have criminal liability for it. There are also crimes that don't require any intent at all. If you remember from tort law, strict liability, blasting dynamite, it doesn't matter how careful you can be with dynamite, you might be liable anyway in tort law. Well, in criminal law, there's some things that it doesn't matter what your intent was, so long as you did it. And the best example I can give of that is statutory rape. So the law for that says if you have sex with a minor, you're guilty of that crime. It doesn't matter what your mental state was. There's some crimes that we just say if you did the act, then we don't require any mental state at all. That's rare in criminal law. And you should understand that again, if we're punishing people and we're doing things like imposing fines, taking liberty, sometimes taking life, we want to be very careful about doing those things to people who had no criminal intent whatsoever, right? But there are some categories of crime like statutory rape where all that matters is whether or not the conduct broke the law or not. So just to recap that, mens rea is the criminal intent, the state of mind that the actor needs to have. And each crime in and of itself is going to dictate what the level is. That'll be found in the statute. It's not that we have to go around and guess, oh my gosh, I'm going to do this. I wonder if they're going to require that I intended it or if I was reckless or negligent. It's in the statute itself. Corporations can be criminal liable also, even though they're not real persons. And so we would, under the law, hold corporations responsible for the criminal acts of their agents, of their employees, of their officers. And that should make sense to us too. All right, types of crimes. We're not going to go over every crime or every type of crime, every category of crime in this class. We wouldn't have time if we did it for the whole semester, but also this is a business law class, and so we don't want to get too caught up in hopefully things that you don't ever run into in your careers. But just sort of a quick overview of different types of crimes. We have violent crime. Everybody is familiar with violent crimes: murder, sexual assaults, rapes, assault and battery, robbery, all those types of things. Usually force is involved or intimidation or some sort of forcible conduct or activity. Those are our violent crimes, and they typically are accompanied by, weapons, dangerous weapons, They typically result in the more pain and suffering or more serious consequences to the victims. Those are our violent crimes. They're classified, too, by degree. So if you've heard on anything you've watched or read, first-degree murder, second-degree murder, third-degree murder, those are just different ways that whoever wrote the statute, whatever state legislature wrote that statute, they are differentiating those crimes into degrees of seriousness. And what they do in that is the different degrees of seriousness, or different, I don't know if I should say seriousness, because murder is serious whether it was first degree or third degree, but they're differentiating between maybe the mindset of the actor, in terms of first degree murder might have required malice, a forethought, meaning it was planned, you intended to do it. Second degree murder might involve some recklessness. Third degree murder might involve some negligence. I'm just giving you an example. Remember, every state legislature can pass whatever laws they want in this area. Criminal law is mostly a state by state type thing. We do have federal criminal laws, obviously, but most of the bulk of criminal law is state driven. So we have property crimes, burglary. Burglary, to surprise a lot of people, a lot of times we think about burglary as theft of something, but burglary is actually breaking and entering the property of another. It doesn't involve the taking. Burglary is just breaking and entering. If I go in somebody's house, but I don't take anything, I could be prosecuted for breaking and entering. Larceny is the wrongful or fraudulent taking and carrying away by a person of the personal property of another. That's the theft part. And you should recognize some of these names of crimes also are names of torts. Remember, we had larceny in tort law. We have assault and battery in tort law. We also have that in criminal law. So larceny involves the actual taking. Obtaining goods by false pretenses. So if someone is trying to defraud another by misinformation or trickery or just outright lies, misrepresentations, that can also be a crime. This is one that was also a tort, so that should also be familiar to you. And so if you're thinking, what's the difference? It would be this. There's some assaults, maybe, or assault and battery. Let me put it a different way. Prosecutors and law enforcement really don't have any way to prosecute and police every single act that may result in the wrong to another. I could commit an assault this morning by threatening to punch Mr. Lester. But is that something that in our limited resources of law enforcement or government, is that something that they're going to actually get involved and prosecute? Probably not. Maybe if I pull a gun on Mr. Lester this morning, is that something that law enforcement is probably going to spend their resources on? I would hope so. So even though you've got acts that can constitute a tort and a crime, you're not always going to get law enforcement involvement just based on the seriousness, whether or not there was actually any harm done, what messages we want to send, that sort of thing. There's all kind of different considerations in why every act that's a tort and a crime wouldn't be prosecuted as both. Does that make sense? There's just not everything is going to find itself, not every act is going to find itself in tort law and criminal law. Receiving stolen goods, it's a crime to receive stolen goods that a person knows, but listen to this, or should have known were stolen or illegally obtained. So sometimes we can impute the guilty mind to the receiver of stolen goods if we find, if the jury finds that they should have known they were stolen or illegally obtained. Arson, y'all are familiar with that. That's malicious burning of another structure or personal property. Forgery, that's fraudulently making a writing that changes the legal liability of another. Those are all examples of property crime. So we talked about violent crime, property crime. We also have public order crime. These are offenses against the good, safe order of society. Public drunkenness, prostitution, illegal drug use, gambling, things that may not have a specific victim as an individual, but those laws are ostensibly designed because the victim would be society as a whole. Public order crime. White collar crime is crime within the business context. And this is probably, it always tickles me a little when I read the textbooks, because we've got a whole huge chapter on criminal law, but we're only going to spend a couple of pages on white collar crime, which would seem to be the most applicable to you as business law students, right? So let's make sure nobody engages in white collar crime. Embezzlement. Embezzlement is the fraudulent conversion of property or money that are owned by one person but entrusted to the care of another. Most of these white collar crimes that we're going to talk about, they happen in legal businesses. So it's not like we can go out and say, well, there's an illegal act, or these things that we might normally think about as crimes. These are done within the cover or within the normal activity of a legitimate business. Embezzlement, stealing from your employer. What the guys in Office Space do, they took a fraction of every penny or something like that. Any big Office Space fans in here? And then they didn't realize that all of a sudden it added up to a lot more money than they thought. They thought nobody would see it, and they ended up embezzling a couple $1 million. And then what did they do? What crime did they commit to cover that up? Arson. That's right. They burned down the office, which is also comical today because everything is in the cloud, right? So that is embezzlement. Mail and wire fraud. Used to be mostly just mail fraud and no wire fraud. Now we have more wire fraud and less mail fraud. But that is just, mail fraud is using the mail system to defraud somebody. Wire fraud would be defrauding somebody by electric means. Does anybody have any, well, I'm not going to limit this to the elderly, but anybody have any elderly relatives that you get mail for, or you see their mail? Have you ever seen the volume of fraudulent solicitations they get? I was about to say it's criminal, but of course it's criminal. One of the things that I do in my job is that there are certain folks, no matter, it's usually our older population, but it doesn't have to be, who are compromised mentally to the point that they can't manage their own affairs. They can't manage their own money. And typically, family members might go to court and get, you've heard about people getting a guardianship. Guardianship is over the person. Like, this is not testing material. Guardianship is if you need to make decisions for somebody, like their medical decisions, or you need to be in to hear their doctor's appointments, or you need to decide where they live. That's guardianship. The other half of that equation is conservatorship. Conservatorship is when you're in charge of somebody else's money and property and finances. And so there are sometimes folks in our county, or in every county, but in this county, who don't have a family member who could do that to be appointed, or they have family members who are fighting, more often than not, that are fighting over mama's money. And so the court will appoint a conservator for the person who's not in the family. And so I've done some of that work where I've been in charge of somebody's property finances because there was nobody else that could do it. And one of the first things that I do when I get involved in that is I have their mail forwarded to my office. And I cannot tell you how much fraudulent mail solicitations they get. And what more often than not brings these cases before the court, what gets their attention is that the adult children realize mama's been sending money to these people. They'll start calling. Does anybody have any other experience with this? You know what I'm talking about? They will call, and if you change the number, they'll start calling your neighbors and saying, I'm so-and-so, I'm trying to get in touch with this person, I can't get them, could you please go give them my number? And when they call, lots of times these folks are lonely, or they establish these emotional connections on the phone with them, where these people look forward to talking to the scammers when they call. And when the scammers don't call, they get nervous and scared, and these scammers play on all kind of emotions. And it really, really is. It's an epidemic problem. I mean, it's a huge problem, but it's really hard to prosecute also, because they'll say things like, we had one guy that they told him, go get $10,000 and then put the bills in the pages of a magazine and then send it to this address in Brooklyn. And he did it. And so, we can't track that. We can't catch that. We got the GBI involved, and it's just really too hard to track. One of the scammers, I got the guy's, I'm getting way off track this morning, but I got the guy's phone number forwarded to me, and they would not quit, even when I'd say, look, the gig is up. I'm a lawyer. I'm representing this guy. I'm running his stuff. There's a court involved. I've called the GBI, they would call and leave death threat messages, but it was like, I would have taken it seriously if I thought it was real, but it was like people with foreign accents calling from another country through something, so I was pretty sure they didn't know where I lived. But anyway, I digress. Pretty far off the track there. What are we talking about? Mail and wire fraud. All right, so mail and wire fraud, that's enough of that. Bribery. Bribery of public officials was when we typically think of, that's a crime. You might be surprised to learn that the crime occurs when the bribe is offered, not when the bribe is accepted. So if I offer to bribe Mayor Skip Henderson to give me a city contract and he says no, I could still be prosecuted for bribery. Doesn't matter whether the person knew it or not. Accepted it or not. But public official bribery is not something that's very common, at least in this country. But commercial bribery is kickbacks, payoffs. Hey, if you get your company to give us this contract, I'll give you a little bit back in return. I'll make it worth your while. Those sort of things are also bribery. We do have a law called the Foreign Corrupt Practices Act that says that even if it's kind of the normal way of doing business in other countries to bribe their governments or their regulators, which it is in many countries, it's still illegal for a U.S. company to do that. Bankruptcy fraud, that's, if you're going to bankruptcy court to get relieved of your debts, you can't give false information. Theft of trade secrets. Remember we talked about that in intellectual property last week. That is something that the company that you stole from could sue you in tort law for that, and they'd be seeking to recover money if you profited from the theft of the trade secrets. But that is also something that could be prosecuted as a crime as well. Insider trading, that makes the news every now and then. That's when you use knowledge that's not public to buy or sell stock. That is illegal. So those are the kind of different white-collar crimes that I want you to at least have some familiarity with. Organized crime, the Mafia, you typically see a couple of different crimes that come up with organized crime. One is money laundering. That's when you're engaged in an illegal business, but you're using a legal business to run the money through. So I own a restaurant, but I'm also a drug dealer, and the money that I profit from selling drugs, I deposit in my restaurant's account, thus laundering or cleaning the money. That's money laundering. You also hear in organized crime racketeering, and that's when that's a loose term for basically organized crime, that we are organized for the purpose of committing all these different crimes as an operation. That's kind of the definition of racketeering. You may hear RICO. That is the Racketeer Influence and Corrupt Practices Act. That's just the law that they use to prosecute organized crime and racketeering activity. Most of the time when you see organized crime prosecutions, it's under the RICO law. That's a federal law. It's under RICO law. There are also, in criminal law, you should know, hopefully not for your personal knowledge, but it is also a crime to conspire to do illegal things, conspiracy. And what's usually required in conspiracy is not that you completed the entire conspiracy, it's that you participated in one aspect of it. So you could be, a person could be prosecuted for conspiracy if they were just part of the planning of a crime. They didn't actually carry it out. They weren't the boots on the ground who were doing the actions, but they were part of the planning. So anytime I keep saying anytime a person is involved in the planning or conspire together to do something wrong, anybody who's involved in the whole thing can be found guilty of conspiracy. There is a whole category of crime called cybercrime. We're not getting into that much because we don't have time, but obviously that is just the crimes that occur in the electronic sphere. It's involving violations of criminal law where you have knowledge of computers or technology. Perpetration, investigation, prosecution happens within the internet community. I mean, you all are familiar with the concept of what cybercrime would employ. So before I move on to defenses, let me just recap where we've been. We talked about purposes of criminal law. We talked about the categories of crimes: violent crime, property crime, public order crime, white-collar crime, organized crime, and cybercrime. Those are kind of the overarching areas that we just sampled some of the different crimes in each area. Now we're going to look at defenses to criminal liability. So remember, in tort law, we had some defenses like assumption of risk or necessity, where it was necessary to commit a certain act in order to prevent another act from occurring. You'll see some overlap in criminal defenses as well. The first one is self-defense. We're all familiar with the idea of self-defense. Another word for that is justification, or the justifiable use of force. So generally, again, this varies from state to state. Depends on how each state defines what's an acceptable use of force to use against force that's being presented to you. Generally, if we're just looking at all the laws and kind of coming up with a general statement, people can use the amount of force that is reasonably necessary to protect themselves. So if somebody comes at me with a stick, then I can't use my AK-47 on them. That would not be a force that was reasonably necessary to protect myself from a guy with a stick. Now, we could argue about how big the stick was. Well, I mean, this is why I'm trying to get y'all to think. We could all come up with scenarios, right, where an AK-47 might be justifiable use of force in response to a stick. I mean, we're creative enough to come up with that. But generally, it has to be reasonably necessary to protect yourself, your dwellings, your property, or to prevent the commission of a crime. Usually for deadly force to be used, you have to have a reasonable belief that imminent death or great bodily harm will result otherwise. So I had to use deadly force because I had a reasonable belief that if I didn't, I or somebody else was going to lose their life or suffer great bodily harm. If the attacker is using unlawful force, that could be another reason that deadly force could be okay. And also, the defender has to be the person who didn't provoke or instigate or initiate the attack. So I can't start a fight and then end it with self-defense. That's not acceptable. So don't confuse the two. There's self-defense in general, And then there's self-defense by use of deadly force. Self-defense in general is just, I need to use the amount of force that's reasonably necessary for me to prevent whatever the harm is going to be. Reasonable use of deadly force would be, I've got to expect that either if I don't do this, I'm going to die or somebody else is going to die or they're going to be harmed greatly from it. That I didn't start the fight and that it's the attacker, the person that I'm using deadly force against, is the one who caused the problem. Your discussion question for this week involves the use of deadly force in self-defense. And it involves a change in Florida law. And I've quoted in the discussion question, I've quoted for you some of the law from the Florida statute, where Florida has actually increased the amount of deadly force that a person can use in self-defense. So the discussion question this week kind of centers around how you, what you think of the way Florida's approach is. So if you'll it doesn't require any reading outside of the question itself, doesn't require any internet research, just requires you to read the question and then give me sort of your thoughts on how Florida's approach is. Necessity is a defense to criminal prosecution. If I am walking down Broadway downtown and I see a fire inside of a restaurant that's closed and I break the front glass of the front window, that's burglary under the definition we read, right? I've broken and entered somebody's premises. But I could use the defense of necessity. Yes, I committed burglary, but I did so to prevent the burning down of the building. Things like that. We could come up. Necessity is, there's not a single definition of that. It would depend on the circumstances of each case. Insanity, that is a defense that gets, we see that in movies and TV shows a lot. Given what we've talked about what's required for a crime, remember the wrongful act and the wrongful state of mind, why would insanity be a defense then? Anybody? Yeah, what does it negate? It negates the guilty, the criminal intent, right? A true insanity defense negates that. Sometimes that gets, people will make insanity defenses when they knew good and well what they were doing. But that's exactly right. That's why that's a defense. If you are, and each state will define what insanity means differently in terms of what it would mean for a defense, not in terms of what it would mean if you were insane or not. Whether you're clinically insane or whatever your diagnoses are, that's a medical question. Whether or not you had the requisite mental capacity to understand your acts and all that, that does involve testimony from doctors and psychiatrists and things. But in terms of whether you are, quote, insane or not for a defense, that's a decision for a jury to make. Mistake. This is an important distinction I want you to know. Mistake of fact is a defense to a crime. I took the backpack that was on the table because it looked just like mine. I thought it was mine. I didn't intend to take the property of somebody else. So remember, in tort law, that was still larceny because I did it. But in criminal law, we're not going to be punished criminally for a mistake. That's a mistake of fact. What is not a defense, and I want you to know this, what is not a defense is mistake of law. I didn't know it was illegal. That is never a defense. We're all charged with knowing what's legal and what's not legal, even though it would be pretty difficult. I could ask 10 questions this morning, and you could probably find 10 questions to ask me, is this illegal or not? And I would have to say, probably it depends, but I don't know. But mistake of law is never a defense. Mistake of fact is a defense. Duress is another defense. That's when somebody's under so much pressure that they have no choice but to do what they want. If I hold a gun to my grandmother's head and tell her to write me a fraudulent check or to forge my grandfather's signature on a check, she's committed forgery, but she has a defense of duress. Somebody made me do it. I was under so much pressure that I was not acting of my own free will. That's duress. Entrapment is a defense when a government officer either suggests or pressures or forces somebody into a position where they have to commit a crime. That's entrapment. That can come up when you see entrapment sometimes with like solicitation of prostitution, where if it's an undercover officer that's posing as a prostitute and the person who solicited the prostitute didn't really ask for it, was all the government actor doing all the suggesting and the acting and the pressuring, that could be an example of entrapment. Statute of Limitations is another defense. Statute of Limitations are a period of time after which you can't be charged with a crime. It also applies in things like, it applies in civil law too, with breach of contract or torts. And that's just because we're not going to have somebody sued or arrested and prosecuted for something that they did 30 years ago or 10 years ago or 5 years ago. There's not one statute of limitations that applies to all crimes. It's different for every crime. Some crimes don't have any statute of limitations at all. For example, murder. You could be charged with murder whether it happened yesterday or 100 years ago. But there are some crimes that after a certain amount of time has passed, you're home free. A person is home free, not any of you specifically are home free. Immunity is another defense. Sometimes prosecution will give a witness immunity if they'll testify on behalf of the prosecution or against a certain defendant. So that can be a defense to a crime. I'm going to try to knock out, which I think I can, some constitutional safeguards, and we're going to talk about criminal procedure here real fast. I'm skipping to the last part of your outline, and then I'm going to work backwards a little bit. But the criminal process, this is also really funny to me. These outlines that I'm giving to you, that I'm teaching from, are the outlines from the actual text that I used to use before I decided to ditch the textbook this semester. And so you'll see I only have 3 paragraphs in here about criminal process. Well, we all know from all the TV and movies we watch that it takes so long from arrest to a person's actual trial or conviction. The criminal procedure as a person works their way through the court system who's been charged with a crime is a lot more complicated than just the 3 paragraphs I've given you. But broadly speaking, the criminal process starts with an arrest. A person is either arrested because there's a warrant out for them or because a law enforcement officer sees them commit a crime and there's no time to get a warrant. Warrants are obtained when there's probable cause to believe that someone has committed a crime. You get a warrant from a judge. So the way that works is the detectives or whoever's involved in law enforcement that's investigating a crime, they've got enough evidence that they believe gives them probable cause. That's a very low standard. That's nothing like the standards we have for conviction or for liability and tort law. It's nothing like beyond a reasonable doubt or even a preponderance of the evidence. It's just probable cause. Does this evidence suggest that this person might have committed the crime? And these detectives will go and find a judge if it's during the day at the courthouse. If it's during the night, they'll call a judge and go out to that judge's house. They'll tell the judge, this happened, this is the evidence that we've turned up in our investigation, and this is what we believe supports probable cause for an arrest warrant. And most of the time, and there are no statistics on this, and I'm not a witness to, regular public doesn't get to listen in to the conversation between the law enforcement and the judge as to what they told the judge to support getting the warrant. But most of the time, the judges will sign warrants. Judges don't want to be wrong. If they're wrong, they'd rather be wrong that we arrested the wrong person than wrong that we didn't arrest somebody who then committed additional crime. But judges give a lot of leeway to the law enforcement who come before them to get warrants. So you could be arrested either because there's a warrant out for your arrest or just because a law enforcement officer sees you do something in real time. That's the beginning of a person's journey through the criminal justice system. The next thing that has to happen is that a person who's arrested has to be presented with formal charges. That's called the indictment. And that is when the person is presented with the details of exactly what they're being charged for, the evidence of why they're being charged of it. And so typically I'm getting not deep in the weeds, but deeper in the weeds. In order to get an indictment, you will usually have a grand jury. Y'all have heard of grand juries? Those are a group of citizens, randomly selected citizens, who come and listen to the prosecutors present the formal evidence and the formal charges, and the grand jury has to decide whether or not there's enough there for the case to proceed. Again, that's a very low threshold of proof. It's not preponderance of the evidence or reasonable doubt. It's just, is there enough here that the case should continue going forward? Sometimes you will see a grand jury dismiss an indictment, meaning that they're dismissing the charges against a person. But it's more unusual than not that a grand jury would decline to issue an indictment. But that is the indictment process. And then eventually a person, I love how the next paragraph is just trial. We get from indictment to trial. We've skipped over things like your arraignment, when the person appears and pleads guilty or not guilty. We've skipped over the bond hearing, where a person would ask the judge to set a bond, that if they post bond in that amount, they'd then be let out of jail while their case is pending. We've skipped over a lot of these steps. We've skipped over the part where the prosecution has to turn over to the defendant all the evidence that they have, especially any evidence that shows that they might not be guilty. That's exculpatory evidence. So if there's any evidence that goes against this person's culpability, that has to be given over to. There are lots of fights between lawyers, as you would imagine, about what is expulcatory and what isn't, and what should be turned over and what isn't. So that's the criminal process. But what I want you to appreciate in that is that there is just a lot more to that than we could ever go through in this class. So I'm skipping back to the section in your outline on constitutional safeguards and criminal procedures. Our Constitution, as we looked at in week 1, has certain safeguards that are built in for every citizen who's charged with a crime. Probably the most one we're most familiar with, or the most famous one, is the right against self-incrimination. We tested that back in the first week. That was under the 5th Amendment to the U.S. Constitution, and that is that you do not have to give testimony that would incriminate yourself in your own criminal case. You cannot be forced to give that. You can't be forced to testify at all in your case. The defendant always has the right to stay silent throughout the trial and make the prosecution prove all the elements of the crime. Even if a defendant does decide to testify in his or her own defense, they still could use the defense of self-incrimination if they're asked a question like, did you do it? Did you shoot this person? Even if they're giving testimony, they're still allowed to not answer certain questions if the answer would tend to be self-incriminating. The 4th Amendment is the amendment that gives us protection against unreasonable searches and seizures. And so that means that no searches or seizures could be performed without probable cause. So the law enforcement can't show up to my house and just say, we want to search your house. You're shady. We want to search your house. They've got to have probable cause. And in order to search my house, they'd have to have a warrant to do it, mostly. There are exceptions for sometimes when you don't have to have a warrant, like when something's happening in real time and police officers see criminal activity going on and they don't have time to call time out, make everybody stay where they are while they run get a warrant. Most of the time, they're going to have a warrant before they do before they do searches and seizures. We have a reasonable expectation of privacy that the 4th Amendment protects before somebody could come and search within our homes, within our computers, within our phones, within things that are personal to us. But for a reasonable expectation of privacy to exist, it has to be a place where we actually expect privacy. Like, I can't be out in the middle of the quad doing something and say, well, you've invaded my privacy. I don't have a reasonable expectation of activity that I conduct out on the quad. Likewise, I don't have a reasonable expectation of privacy on my public Facebook page or my public Instagram page. I want everybody to hear that. It is perfectly legal for people to stalk your Instagram and Facebook and social media profiles if they're public. That is not an invasion of privacy. Now, it could be an invasion of privacy if they catfish you and you do have privacy protections and somebody obtains entrance into your private world by trickery or fraud. But if you put something out there in public, if you've commented on somebody else's Facebook page or Instagram page that's public, you don't have an expectation of privacy on that. That's fair game. A couple of other Fifth Amendment protections in addition to self-incrimination. One is due process. Due process is a phrase that gets thrown around a lot, and I think due process is confusing because it's hard to understand. What due process really means is fairness. That in order for somebody to have to be prosecuted, to be charged with a crime, to be arrested, in order for somebody to be put on trial, in order for somebody to be accused of something, the process has to be fair, and it has to be conducted in accordance with the laws that we have for it. The process has to be fair, and the prosecutorial actions have to be fair. So I can't be arrested and not told what I'm being arrested for. That's not fair. That's in violation of our criminal process laws. I can't be tried for a crime and not be given a right to cross-examine the witnesses of the people who are testifying against me. Those are all due process concerns. Was the process fair to the person? Did they have the opportunity to present all the evidence that they needed to? Did they have a fair opportunity to defend themselves against the charges, both with the actions of prosecutors and did they follow the laws of criminal process? That's all due process. Double jeopardy, we're familiar with, is that you can't be charged with the same crime. You can't be tried for the same crime twice. I have to be a little bit careful of that because remember, the same act could constitute some different. I said the same act could be a tort and a crime. The fact that OJ was found not guilty of murder didn't prevent the same actions from being a basis for a tort lawsuit. The same actions could also be a basis for another criminal lawsuit. So if I don't know what all of the crimes that OJ was charged with, but I would bet that they could go back and look at some of the actions that they allege that he did and think of some other crimes. Like, I'm not sure if they charged him with assault and battery or assault with a deadly weapon. I mean, they probably did. Typically, the prosecution will throw in any charge that they can think of that those actions fit into. But it's certainly possible that one action you could be found not guilty for this crime. It means you can't be tried for that crime. It doesn't mean you can't be tried for a different crime if your actions also fit the definition of that. You don't see that happening very often, but I just don't want you to confuse what double jeopardy is. Double jeopardy just means you can't be tried for the same crime twice. There is something called the exclusionary rule. That's a constitutional protection, and that means that if any evidence was gathered against a person and that evidence was gathered illegally, let's say it was from an illegal search or seizure, or it was gathered without a warrant, or a person was given their Miranda rights and they requested a lawyer and the police continued to ask them questions even though they've requested a lawyer and they get a confession. So if anything is done wrong, if anything happens wrongfully in the process, then that evidence cannot be used against the person. that evidence is excluded. So if the police come to my house with a warrant and they search my house and come up with all this, they seize all kind of evidence that they think shows that I've committed a crime, but it turns out that their warrant was wrong, the warrant was not obtained rightfully. That was either there wasn't probable cause, or they exceeded the scope of the warrant. There are all kind of problems you can have with warrants that we're not going to get into. But what it does mean is that if there's something wrong with that warrant, anything that they found in my house is now off limits to them to use against me in the prosecution. That's the exclusionary rule. We have the Miranda Rule. You know that from TV and film, that you get to be read your Miranda rights. Hopefully no one can recite those by memory, but that is ones you're familiar with. You have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney, all those sort of things. Wow, I actually finished early on this. Any questions about criminal process from today?